Hey guys, let's get into this recent motion by the prosecution and the defense, and the three critical calls on Brian Koberger's process or progress. And I do want to apologize to my subs for my moderator's meltdown in the live chat. I have now removed her as my moderator. Let's get into this video, guys, and thank you for sticking by me through all of this.
Other places in the state are giving different instruction that it should be beyond a reasonable doubt.
What I'm telling you, court, is that it appears that up until 1980, that was true.
Defense attorneys for Brian Koberger make a compelling argument to throw out his grand jury indictment as the accused murderer wants this case to just go away. We've got the top three things you need to know about the defense's claims and what went down in court, including the ultimate major decisions from the judge. Welcome to Sidebar, presented by Law and Crime. I'm Jesse Weber. So is the case against Brian Koberger going to continue? That was the question this week that had to be answered in court, and we're going to talk about it right now. So Brian Koberger, of course, is the former PhD student accused of stabbing to death 4 University of Idaho students last November in an off-campus home. Kaylee Gonsalves, Madison Mogan, Ethan Chapin, Zana Kernodle. He's currently facing 4 first-degree murder charges as well as a burglary charge. We know a lot of the evidence against Koberger, the cell phone data, the surveillance footage, his car, a match to DNA found at the crime scene, a potential eyewitness ID from a survivor in that house. But we also know that prosecutors presented their case in secret to a grand jury, and a grand jury returned an indictment against Brian Koberger. Well, that brings me to these latest set of hearings, because leading up to this, the defense has argued that that grand jury indictment should be thrown out, basically asking for this case to be dismissed. So first, there was one hearing that was held between the attorneys and Judge John Judge. That's his name, Judge John Judge. And this first hearing was held in private. There were no cameras. The decision hasn't been released. It concerned alleged bias by the grand jury. The reason it was closed is because by nature, grand jury proceedings, and of course, who the grand jurors are, is secret. But after that, we did have a public hearing. And first, the judge dropped a major decision that we weren't expecting.
I'm sure you're probably interested in this. I haven't put a decision out yet, but what I'm going to do is take control of the cameras in the courtroom. I'm not going to ban cameras in the courtroom, but I need to have more control over what the cameras are doing and what media or people who are not media are doing with the filming. I know I can only control so much, and that's why I continue to urge people to be patient and have some dignity and some restraint.
Picture your future. Where do you want to be in 5 years? What are you doing to get there?
Now, that is very big, because there has been much debate about whether there would be cameras in the Brian Koberger trial. And based on Judge Judge's statements, it seems that we're going to have them. Or maybe I should say, as of right now, the Koberger case and its proceedings will have cameras. Hopefully we'll have it by the time trial comes. But it is not clear what he means when he says he's going to take control. Maybe that means they're going to use the court's own camera and not a media pool feed. We'll have to see. But one of the issues that has surfaced was the idea that the camera was spending too much time on Brian Koberger. And that's problematic. You know, it could taint a jury pool if they're turning on and all they see is this image of Brian Koberger, close-up shots of him. It's unfair public coverage. If all the focus is just on the defendant, whatever the case may be, this is a big win for transparency, a big win for seeing this process play out, because so much of this case has been in secret. There's been a gag order in place. So this is a huge decision. Me personally, I love it. All in favor of cameras in the courtroom. Great decision. Okay, now let's move on to what the attorneys and the judge really were there to discuss that day. And that was the defense's motion to dismiss the indictment on the grounds that the grand jury instructions, what they were told, was wrong. I have to tell you, this is a very, very interesting argument from Kohberger's defense. And honestly, I don't believe I've ever heard of it before. So it goes like this. It's a little complicated, but stay with me. So the grand jury indictment of Kohberger should be thrown out because the grand jurors were given the improper instructions as to the standard of proof. You see, while they were instructed to return an indictment if they find probable cause exists, meaning there's reasonable grounds to support that Brian Kohberger committed these crimes, which, by the way, is the typical standard across the country in grand juries. And it's a relatively low standard, low burden. They always say that you can indict a ham sandwich because the standard is so low. The defense is arguing that that is not the standard under Idaho law. The defense is saying that if you look at the Idaho statute, grand juries should only return an indictment if they find proof beyond a reasonable doubt. Now, not only is that standard higher than probable cause, it is actually the highest standard we have in criminal law, the highest legal bar. The reason the defense says this is because under the Idaho code, the Idaho statute, it says, quote, the grand jury ought to find an indictment when all the evidence before them taken together, if unexplained or uncontradicted, would, in their judgment, warrant a conviction by a trial jury. The defense says, well, if you are saying the evidence would mean a conviction at trial, then that is beyond a reasonable doubt. That's the standard at a criminal trial. They're saying it's equal. So since the grand jurors were instructed, as the defense says, on the wrong standard, they say the indictment has to be thrown out. In other words, the defense is saying maybe the grand jury would have come back with an indictment anyway, but you have to hold the prosecutors to their burden. They have to show more evidence. There's a higher standard. So here's the thing. They want the judge to either toss out the grand jury indictment, dismiss the case, or send the case to a preliminary hearing to decide if there's enough evidence to go forward with a trial against Kohberger. You see, if the case goes to a preliminary hearing and not a grand jury, then it's decided by a judge, not a grand jurors. And it's not secret like a grand jury. The defense can hear the prosecution's evidence. They can even present or challenge some of the state's evidence. By all accounts, now that we know that cameras would be in the courtroom, it would be televised. Now, obviously, prosecutors went with the grand jury against Kohberger because, in a way, it's easier. It's more streamlined to get an indictment that way than through a preliminary hearing. So now you've heard what the defense's argument is. Clearly, the prosecution's not agreeing with this. Let's hear the arguments in court. Here is Kohberger's attorney, Jay Logsdon. And first, he's explaining that the Idaho code, the statute, means beyond a reasonable doubt, and how we're just discovering this issue today because it seems Idaho has consistently been using probable cause for grand juries, and that might be the wrong standard.
And the first question that a court has to ask is, what does that mean? And you start with the plain language, which we argue. What warrants a finding or a conviction by a trial jury is beyond a reasonable doubt. And it meant that back in 1887, when the territory took all of these statutes, almost entirely from the state of California, and it means it today. And then we also pointed out that the great state of California, when they had these on their books from back in the 50s, had already a case in 1962 where they said that it's clearly something more than probable cause, but they weren't too specific about exactly what it meant. And so I'm now put in a position of trying to explain why that occurred and why, in the year of our Lord 2023, we are suddenly finding out that that's not quite how things are supposed to be. Why did we forget that we passed all these laws? And I don't have a great answer for that, but nobody's really been digging into this or raising it until this time. So when the court says, look, the Supreme Court's already got a rule on this, Supreme Court's already ruled on it, it's just not true. They have never ruled that probable cause is the basis because there was an argument about it. And they said, no, you're wrong, it's probable cause. That hasn't occurred. They ruled a lot of things, but that's not one of the ones.
I decided to try out a Casper mattress, and let me tell you guys, that is the best decision I've ever made. After just one night.
And then he says, well, if the grand jury was instructed as to the wrong standard, not only is their decision not accurate, not only is that indictment valid, but he gives us a behind the curtains look at what the grand jurors may have been thinking. Yeah, he kind of says something here that he shouldn't. And he explains that if the grand jurors were given the higher standard, they may not have returned an indictment.
What it's intended to do is just make it so that if you're in a position to get an indictment against somebody, you're going to put on your A game. But obviously, we've been talking a bit about how we don't think that that's what occurred in this particular case. And we certainly don't think that if the court were to adopt this particular case, that this would even remotely cut the mustard, because we know from the grand jurors that at least 6 of them wanted to hear more until they were essentially cut off and told probable cause is the standard and what do people do?
You probably should cut that, what the grand jurors did or didn't do.
That is interesting. Grand jurors on the fence wanted to hear more evidence. That's a pretty big bombshell, and the judge stopped him there. Well, then Logs then says, okay, now for all of you out there who are like, okay, wait a second. If now we force grand juries to only return indictments if they have to meet this higher standard of proof beyond a reasonable doubt, we're never going to get indictments, right? It's going to be chaos. He says that's not the case. There have been convictions. There won't be this kind of issue as people claim. And then the prosecution, after the defense had the chance to make this argument, they had their chance to respond and basically said, look, this is the law of the land. Probable cause is the standard. It's constantly and consistently been upheld.
So in Edmondson, the Supreme Court said, and I quote, "The purpose of the grand jury proceeding is to determine whether sufficient probable cause exists to bind the defendant over for trial. The determination of guilt or innocence is saved for a later day. As long as the grand jury has received legally sufficient evidence, which in and of itself supports a finding of probable cause, it is not for an appellate court to set aside the indictment." This court is bound by that holding. The Idaho Supreme Court applied that holding in 2 subsequent cases, Martinez and Jones, both cited in my brief. The Court of Appeals has applied that holding repeatedly. This court is also bound by its holdings.
Basically saying there's no issue here. Well, now Judge had the opportunity to give his take.
To just say, well, they were given the wrong instruction is not exactly the case. I mean, that is the standard that has been used in Idaho for years, maybe 100 years.
I'm taking a fight about it.
And you may have the opportunity to do that to the Supreme Court.
Well,
And that's what you're building. That's what you're building for. Because you know that I am constrained by existing law. I can't just change the law as a trial court. I appreciate the argument. I think it's really creative. I am going to deny that argument. I think the argument is good, but I can't go that far. Not today.
So the judge actually appreciated the argument, but he can only do so much. He's not the Supreme Court, where perhaps Mr. Logsdon should argue this if he wants a change in the state. So the motion was denied, meaning the indictment stands, and Bryan Kohberger is still headed to trial. And that's all we have for you here on Sidebar, everybody. Thank you so much for joining us. Please subscribe on Apple Podcasts, Spotify, YouTube.
Let's get into this order to seal and redact the Reddit posts. This matter comes before the court February 10th, 2023, on the court's motion to seal or redact pursuant to ICAR 32. The hearing was held on Zoom. William W. Johnson Jr. and Ashley Jennings appear on behalf of the state. Ann Taylor appeared on behalf of Mr. Koberger. The court reviewed the records, considered the arguments presented, weighed the interest in privacy and public disclosure, and announced its findings of fact on the record. Therefore, pursuant to ICAR 32-I-2-A and D, the court finds it necessary to seal, impart, and redact the record related to the search warrant for the following reasons. The documents contain highly intimate facts or statements, the publication of which would be highly objectionable to a reasonable person, and the documents contain facts or statements that might threaten the safety or endanger the life or safety of individuals. After due consideration with good cause appearing, I hereby ordered the record herein shall be disclosed except for the following. The affidavit in support of search warrant is sealed. The search warrant and receipt and inventory be redacted. The order will remain in effect until further order of the court. Based upon the motion to seal, search warrant and related documents filed herein, the court does hereby confirm and order that the affidavit for search warrant, including any exhibits, search warrant, return of search warrant, including the inventory of items seized, in order are confidential, exempt from disclosure, and are sealed pursuant to Idaho Court Administrative Rule 32 G1 for the reasons stated in said motion until March 21st, 2023, and further order of the court, whichever occurs first, so ordered. The state of Idaho, by and through the Latah County Prosecuting Attorney, respectfully moves the court pursuant to Idaho Administrative Rule 32G1 and Idaho Code 74-124 for the order sealing search warrant and related documents, including the affidavit for search warrant, including any exhibits, search warrant, return of search warrant, including the inventory of seized items seized, and order filed herein because a release of disclosure would interfere with enforcement proceedings. Motion to seal search warrant and related documents redacted. Continue an unwarranted invasion of personal privacy. Disclose the identity of confidential sources, and disclose investigative techniques and procedures. And the state seeks the protection for a minimum of 90 days or until such time as the investigation is concluded and or charges are filed. Wherefore, the state respectfully prays that the court seal from public disclosure the affidavit for search warrant, return of search warrant, and order herein until the provisions of Idaho Court Administrative Rule 32G1 and Idaho Code 74-124 respectfully submitted on this 22nd day of December 2022. I, Lawrence Mowry, the officer by whom this warrant was executed, to certify the apprehended inventory contains a true and detailed account of all property taken by me or other officers pursuant to this warrant, and that this warrant and property may have duly returned before the court at 9 o'clock on this 22nd day of December 2022. I certify under the penalty of perjury pursuant to the law the state of Idaho that is foregoing. Search warrant redacted. I, Lawrence Mowry, being duly sworn, do hereby state the following information is true and correct to the best of my knowledge and belief, that I, employed by Moscow Police Department in the official position of forensic detective, affidavit has been trained and qualified peace officer for 12 years. On November 20th, 2022, I obtained a search warrant for reddit.com. The warrant was served December 1st by mail, fax, email, etc. On December 19th, I received an email from reddit.com which contained the requested information. An inventory was prepared for all items received, and the information received was placed into evidence at the Moscow Police Department. I certify or declare under penalty of perjury pursuant to the law, the state of Idaho, that the foregoing is true and correct. On the first day of December 2022, approximately 2:09 p.m., the following peace officers, Detective Lawrence Mowry, served the search warrant heretofore issued upon the place and or person described as directed in said search warrant. Entrance was obtained by the person or persons found in said place were the property found and taken at the location, and the location within or upon said place or persons were as follows: Kaylee Gonzalez, 4818. The receipt and inventory were made in the presence of, that's blank. A copy hereof was left on this date in the conspicuous place in the place searched, there being no person present during the search, dated this 22nd day of December 2022. In the above entitled matter, the court having heretofore issued a search warrant and the said search warrant having been served according to law, and the return of warrant having been duly made as directed in said search warrant to this court, and a written inventory of the property found and seized having been duly made and taken before the undersigned magistrate or judge was filed herein. Now therefore it is hereby ordered that the said peace officer shall deliver or cause be delivered the property described in said inventory to the Moscow Police Department or such other law enforcement agency as may be appropriate for the purpose of preserving said property for use of evidence, or until further ordered of a court or a competent jurisdiction. Once any related criminal case has been concluded, including the expiration of time for appeal, or at such other appropriate time, the property can be released or disposed upon the authorization of the jurisdictional order. It is further ordered that said property thereof may be delivered to any person or laboratory or laboratories for the purpose of conducting or obtaining any test, analysis, or identification of said property, which deemed necessary by the custodial law enforcement agency or jurisdictional prosecuting attorney without further order of this court. Sounds like he's being railroaded, guys. any other peace officer authorized to enforce or assist in enforcing any law of the state of Idaho, Lawrence Mowry, having given me proof upon oath this day showing probable cause, establishing grounds for issuing a search warrant, and there is probable cause to believe that the property referred to and sought in or upon said premises consists of information related to the crime of homicide on the Reddit account of Kaylee Gonzalez, with any of the following identifiers: Kaylee Gonzalez, mobile phone number of 4818, email address is redacted, and or generated on or between January 1st, 2021 to present, including all basic subscriber information, such as information collected when a user creates a new Reddit account, alters information on a later date, or otherwise interacts with the Reddit website or the application app, including but not limited to Reddit users, subscriber, known legal name, identity, email address, phone number, search warrant redacted. Why did they want to get Kaylee's Reddit information? That don't make no sense. Reddit display name, Reddit account creation date, and internet protocol, IP address, timestamp, and IP address of Reddit account, logins and logouts, address, date of birth, gender, billing information, expanded subscriber information, including but not limited to non-content related records and or information about the above listed target user and or accounts, including but not limited to user preferences and communication headers, any and all records concerning the above listed account holders, identifiers, including but not limited to metadata about a user's account, any stored user files, including all photographs on their original file formats, including metadata information, location data, including but not limited to any and all records concerning the above listed target users and or accounts, including but not limited to location data, Reddit user communications, including but not limited to public posts, comments, votes, and other information regarding the substance of the target user's accounts, publicly available communication, private, non-public messages, and or communications between the users' accounts, posts, comments, votes, and other information regarding the substance of the user accounts, non-public communications, internet protocol, address information, including but not limited to all IP address information regarding the IP address used at the time of the account creation, and any IP address information stored by Reddit for the above listed target users, other identifying data if collected by Reddit, including but not limited to any information on the device used to access the target accounts, including the type of device, mobile number, international mobile equipment identifier, IMEI numbers, phone numbers, global positioning system locations, and or IP addresses. That don't make no sense, guys. Why are they looking at Kaylee Gonzalez's Reddit? This court will be electronically submitted to Reddit via the online law enforcement search warrant. You are therefore commanded to search the above described premises for the property described above, to seize it if found and bring it promptly before the court above named. This warrant shall be executed within 7 days of issuance and is authorized for daytime service only pursuant to Idaho Criminal Rule 41. Daytime means the hours of 6 a.m. to 10 p.m. Pacific Standard Time under the following special conditions. The search warrant is issued for law enforcement purposes. Reddit is ordered not to disclose the existence or contents of this search warrant for the information furnished in response to the search warrant for a period of 90 days or until further ordered of the court. Reddit shall disclose the described property and information within 14 days of issuance. The above matter having come before the court based upon the motion of the state and good cause appearing, is hereby ordered that the time for which the above referenced search warrant shall be returned is extended to March 14th. I do hereby certify the true and correct copies of the order for extension to return search warrant were served on the following in the manner indicated below. The state of Idaho, by and through Ashley S. Jennings, Latah County Senior Deputy Prosecuting Attorney, moves the court for an order extending time for returning the above referenced search warrant, which was issued December 2022. The search warrant was directed by the court to be served within 14 days of issuance. During business hours, the warrant was served by Detective Lawrence Mowry on December 1st, 2022 by email. However, as of this date, the information has not been received, although the warrant was executed within the 14-day time frame directed by IC 1944412. The state is not able to comply with the time frame within which to return the warrant and provide a written inventory according to the state request an extension for the time for the return of the search warrant respectfully submitted 14th day of December 2022. Okay, why were they wanting all of Kaylee's Reddit posts and Reddit information? I could understand Brian Koberger because he's charged with this heinous crime, but why Kaylee's Reddit posts and Kaylee's Reddit information? Were they looking at her for something too? That don't make no sense, guys. I promised I would keep up with this case to my subscribers, and that's just what I'm doing. Y'all have a good night, and I'm sorry about my mod. I have now demodded her for her meltdown in the chat, and I'm truly sorry for her behavior. You guys have a good night, and I'll keep plugging away.